Welcome back to class. For this session, we want to talk about the Supreme Court and how it operates. The Supreme Court was created by the Constitution, and it is the pinnacle of the federal court system. It is composed of 9 justices who are appointed for life terms by the President and confirmed by a simple majority vote of the U.S. Senate. Even though the Supreme Court decides relatively few cases per year, those decisions carry weight due to the principle of stare decisis, which literally means to stand by that which is decided. Courts must be consistent with decisions reached in the past on similar kinds of cases. The pressure of stare decisis is exerted downward from the Supreme Court to lower courts. In other words, when the Supreme Court makes a definitive ruling on a matter of law, that decision sets a precedent for other courts to follow in subsequent cases. 2 caveats apply. The case at hand must be similar enough to the one that set the precedent, and a later Supreme Court can always decide to change precedent by overturning a previous Supreme Court's decision. Thousands of cases get appealed to the Supreme Court every year, but they take only a fraction of those. By tradition, the rule of 4 governs whether the Supreme Court takes a case. If 4 or more justices agree to take the case, then the court issues a writ of certiorari, which is an order to the lower court to forward the case to the Supreme Court. The people or groups involved in a case are called the litigants. The petitioner brings the case or the appeal, and the respondent answers. Here's a picture of Linda Brown, whose father, Oliver, was the petitioner in the case Brown versus the Board of Education of 1954, in which the Supreme Court ruled that segregated schools were unconstitutional. The lawyers for the petitioner and the respondent file legal briefs with the court. Legal briefs are simply written legal arguments as to why one side should win. They appeal to precedent in previous Supreme Court and other federal cases. In our system, people and groups who are not directly litigants in the case are also allowed to file legal briefs on behalf of one side or the other. These are called amicus curiae briefs, literally friend of the court briefs. The justices are not obligated to read the amicus briefs, but they often do. Amicus briefs are filed by state governments, interest groups, and rich individuals. After briefs have been filed, the court schedules oral arguments in the court chambers. The lawyers for the litigants each get 30 minutes to present their case orally to the justices. During this time, the justices often interrupt the lawyers with questions. Oral arguments are open to the public, but you have to stand in line in hopes of getting in. The Supreme Court operates on majority rule. If 5 or more justices support one side, then that litigant wins. The Supreme Court doesn't just announce the winner, but issues a majority opinion. One of the justices in the majority writes an often lengthy justification for the decision. The majority opinion lays out the line of precedent that the court found compelling. The majority opinion sets precedent for all lower courts and instructs legislatures around the country as to what kind of legislation is likely to be constitutional. The justices who voted in the minority also explain their reasoning in what is known as a dissenting opinion. The dissenting opinion does not set precedent and carries no legal weight, but dissenting opinions are important nonetheless, particularly when the court changes precedent years down the road.